Hey everyone, I'm Linda Loveland here with Jake Parker, General Counsel for the North Carolina Farm Bureau. Big ruling came down late last week, which is, it seems like when all these rulings seem to come out, but this is dealing with the right to farm law and a big deal. So let's back up a little bit and explain what this sort of means and how this sort of started, the constitutional challenge to this.
The origins of this go back to the 2013-2014 Smithfield Farm lawsuits, which you recall we had hundreds of plaintiffs filing lawsuits against Smithfield and against 80 contract growers, many of them Farm Bureau members. Yep. The claims there were that the farms were creating nuisances for various reasons. And we thought that the right to farm law, which protects farmers against nuisance lawsuits, and every state has a right to farm law, we thought that that would protect Smithfield and our farmers against those lawsuits. But a federal district court judge said, no, the law doesn't apply. And we thought this is really a big problem. So we went to the legislature in 2017 and 2018 and asked them to restore and strengthen the right to farm law. They did that. So what happened next was the folks who opposed that law, or those two amendments in the General Assembly, went to the courts and tried to challenge the law as being unconstitutional.
And so that's what all this this has been going through the system for a while, as it usually does.
Yeah.
So then last week, the Supreme Court said, in a 6-1 decision, were you surprised by that? That said, the law holds?
I wasn't surprised that the court said they don't want to take the case. And backing up just a little bit, so the claims that the plaintiffs made were the law violated North Carolina's Constitution because it did three things, they alleged. One, it violated some of their property rights. Two, it was a special law that was intended to only protect Smithfield, which we believe was obviously far from the case because we have farmers all over the state who were impacted by this. And then that it violated their right to get a jury trial, which of course we didn't agree with it either. Yeah. So those cases, because it was a facial constitutional challenge, here's your legal nerd info for the day. A facial constitutional challenge means a plaintiff is trying to say the law cannot apply constitutionally to anyone at any time. And so when you have one of those challenges in North Carolina, it has to go before a 3-judge panel of trial court judges. That happened in December of 2020. Yep. That court said, we're going to dismiss this case, there's no claim here. Then the case went to the plaintiffs appealed to the North Carolina Court of Appeals in 2021 in December. They said, we're affirming the ruling below, there is no case here. So then the plaintiffs asked the North Carolina Supreme Court to take this case.
They just kept working their way up, essentially.
And the North Carolina Supreme Court, like the U.S. Supreme Court, doesn't have to take every case that comes before it. It gets to pick and choose the cases it wants. Yeah. So the 6-1 ruling from Friday was, we're done. There's no more need to review this case in the appellate courts. And so it was a big win. I wasn't surprised by that. The one judge who said that she would have voted to hear the case, that surprised me a little bit. That usually doesn't happen, but it happens.
So facially, you said that's so that part is done.
That's correct.
But there's still potential for something.
There's always the potential for lawsuits, as you and I know very well. Yeah. And so there could be cases that pop up on individual farms or in individual circumstances that may come up, and plaintiffs may say the law is unconstitutional as it applies to me. We call those as applied challenges. But we'll just have to wait and see what happens there. But this was a really big win. The law is constitutional. It does apply, the court has said, in constitutional ways, and that's a really big deal for our farmers.
So again, no one can challenge that part of the law. So that's done and over, and just that's a good sense of security.
That's right. It is a really welcome Christmas present.
Wow. And I know a lot of other states have been looking at our right to farm law, right? I know they've been...
Several states have passed laws similar to ours. Florida, Utah, West Virginia, they all made changes to their right to farm laws that look very similar to ours. So our ruling from our state Court of Appeals and then our Supreme Court saying what happened below is okay, that's a really good sign because it means those laws are likely constitutional as well.
Well, I know this is one thing that you all have been working on very hard in the last few years since I've been here at Farm Bureau too. So that's, kudos to you all for digging in and making that happen.
Thank you. It was a real team effort. The leadership we get from our Legal Foundation Board, our farmer members across the state. I would also say our outside law firm, Smith Anderson, did a great job on this case. And we also had great cooperation from the legislative leadership and the Attorney General. Those folks don't always get along. And so to see them work together on this case, it was so important to agriculture in North Carolina. It's a really big deal.
All right. So right now we'll celebrate the win. I think
Absolutely.
that's kind of the thing to go with. So
Yeah.
it's a great season. Celebrate a win.
That's right.
All right. Thanks, Jake.
Thanks, Linda.